Mr. Chairman, we are live.
Thank you. Welcome to Judiciary. Another day of the House Judiciary Committee. Today we'll be considering Senate File 49, Deferral of Criminal Sentence Amendments, and Senate File 75, Protective Orders Amendments. Kay, will you please call the roll?
Representative Crago.
Here.
Representative Larson.
Here.
Representative Oakley.
Here.
Representative Provenza.
Here.
Representative Williams. Vice Chairman Washut.
Here.
Representative Yin.
Here.
Representative Swanitzer.
Here.
Chairman Olson.
Here.
Mr. Chairman, you have 9 people present.
Excellent. All right. Senator Case, welcome.
Thank you very much, Mr. Chairman. It's a pleasure to be back here. I used to serve on the House Judiciary as my very first committee. So Harry Tipton was the senator, and Pat Nago was on there, and Louis Tomasi, a bunch of guys you wouldn't know, but a lot of them are all dead now. Everybody I just mentioned is. I hope you guys do better. Mr. Chairman, you will. We were all as young as you, I promise. So I bring you Senate File 49, Deferral of Criminal Sentence Amendments. Mr. Chairman, I'm sure you understand the bill. It deals with, I'm sure Representative Oakley understands the bill. It deals with Section 7301 of our code, which is the opportunity to defer a sentence. It's a very useful tool to have for first-time offenders to receive the opportunity to go to the court and to have their sentence actually deferred, not entered into the record. And then if they comply with conditions and reform themselves and serve well, then their sentence is actually never entered, and they get a free bite at the apple. That's Part A on the bottom of the page, and basically it says, if a person has not previously been convicted of any felony, is charged with or found guilty or pleads guilty or no contest to any misdemeanor, then there's a list of exceptions. There's some things that you cannot get a 301 for, and that goes clear down into line 6 on the next page. This is the key part. It says the court may, with the consent of the defendant and the state and without entering a judgment, come up with this sentence deferral. What this bill does is takes those 3 people that are involved in this deferral, which is the defendant, the judge, and the state, which would be the prosecuting attorney, and say, well, should we really let the state have a veto, in essence, on whether there should be a deferred sentence or not? It's a policy question, it's a philosophy question. I lean on the side that the sentencing, in the terms of the sentence, that's the purview of the judge, and that's who should be making the decision. I think that you're going to hear from some folks that want to testify how that can be misused if that power lies within the prosecutor's office. So with that, that is the bill. And the only reason I don't have a sponsor is because you guys don't return your co-sponsorship request cards. In a timely manner.
In a timely manner.
That's it, Mr. Chairman. There are folks that would like to testify, I think.
Thank you. And Senator Case, just to, I guess, get it out there and clarify on the record. So you said there was a list of felonies this doesn't apply to on page 2. This doesn't apply to murder, sexual assault in the first or second degree, aggravated assault, battery, arson in the first or second degree. So some of our most heinous crimes, we're not talking about those right now.
Absolutely correct, Mr. Chairman. Well put.
And I don't know if you've dived into this, maybe if not, we may be able to get it through some other testimony, but when we're talking about, so we're talking about a different category of felonies than these heinous felonies. But there are certain rights that a person loses when they have a felony. Voting and gun rights, voting rights. Is that accurate? Is that accurate understanding?
Yes, certainly, Mr. Chairman. Thank you very much. You also, there are employment and future restrictions that can occur. To not have those be on a record that is truly a reformed person who has complied, I think is a great thing. it's a unique opportunity. We've expanded it over the years, and I think by all accounts, it's been a very good thing.
Vice Chairman Washit.
Thank you, Mr. Chairman. Senator, can you give us some examples of abuse by prosecutors when maybe they've misused the participation in these proceedings?
Mr. Chairman, I'll do my best, but others I think will be able to do a better job. In essence, it becomes part of the package of the things you have on a defendant to get them to cooperate. And so it affects, you may have a defendant that's very interested in pursuing a 301. Their case, you know, whether they're guilty or innocent, could be on any side of that, but they're so they see the opportunity for a 301, and that's the carrot that's handed out to them. They may actually plead guilty to something maybe they shouldn't have pled guilty for to get the 301. There are other abuses. It's sort of like having, it's the carrot side of the extra charges that a prosecuting attorney can put on, you know, and to kind of shake the tree and make you conform. You know, and I really believe as a matter of principle and philosophy, that's whether you, this is sentencing purview, and this is the purview of the judge. And I just might add, Mr. Chairman, it has changed in Wyoming law. It was a different way at one time, and then it was added. So I will say that.
Representative Oakley.
Thank you, Mr. Chair. Good afternoon, Senator Case.
Good afternoon.
So you've said a couple times that it should be a sentencing decision. So tell me what your thoughts are about how this improves the situation for a defendant where the way plea negotiations usually go and always go, and including with this 301 offered by the state, is before they have pled guilty. Mm-hmm. So if I'm understanding what you're saying, and that is my understanding of what would happen, the defendant has to plead guilty to a charge first, and then come what may with the judge, right, rather than having a plea agreement in their hand when they go to plead. If you wait until sentencing, I think that actually makes it much less of a desirable position for the defendant. So what are your thoughts about how what this does is take it away from plea negotiations and puts it, they have to plead guilty in order to ask the judge for this consideration?
Mr. Chairman,
Senator.
Representative Oakley, thank you very much. I certainly agree that it's a person that has to, you're guilty when this is all over. You're guilty, but the sentence is deferred. There's no question that you get there. What I would request possibly is you will hear some of the stories that folks will be able to tell you from the defense attorney side about how this is misused. And they can do a much better job than I can to explain the abuses. I've actually never been in a 301 proceeding. So, and I know that the good representative has, and many of you have. But there are other people that,
Senator Case.
Yeah, it is a good thing. I'm still young, so, but if I could, maybe we could come back to that after some other folks testify and clear that up.
Yeah, I think that's a good idea. We'll definitely hold that. We'll revisit that question. Representative Oakley.
Thank you, Mr. Chair. Senator Case, and I'm assuming we'll probably go the same with this case, but with this question as the last one, in that you'll want to revisit it afterwards. But so a couple times the word misused has been used. Mm-hmm. So for clarification, what you're saying misuse is when the state, the prosecution, who knows the facts of the case, the criminal history, has spoken with the victim, all of the things that prosecutors do in a case, probably for months prior to, they don't believe that specific defendant is appropriate. So that's what you're characterizing as the misuse of the offering of a deferral.
Mr. Chairman,
Senator.
I kind of think you're trying to put words in my mouth. So
Yeah.
honestly, it's the prosecuting, the state, the prosecuting side will have the opportunity to argue the issue of whether there should be a deferral. I have no problem with that. They can say, you know, we know a lot more about this, judge. Don't give them the deferral. We recommend there not be a deferral, on and on and on. That's fair. Absolutely fair. But giving them the veto when that hasn't come about in a contested thing, but just have one side have a veto, I don't think that's fair. And there are people that want to testify on this. I hope we get to them.
Yeah, let's move into some testimony, because we've got some agency testimony that's gonna appear. Let me get my Zoom going. We got a lot of folks in the virtual world that want to testify, but what I'm going to start with is agency testimony, because we definitely have court schedules to deal with. So I'm going to admit Ms. Bennett from the Public Defenders. And I do think that will help the conversation with Representative Oakley's questions as well. Good afternoon, Ms. Bennett. Please introduce yourself and let us know. Let us know your thoughts, of course, on the legislation. And if you have any comments to Representative Oakley's questions, certainly feel free to weigh in those, or we can go back to Representative Oakley with those questions.
Thank you, Chairman Olson. My name is Patricia Bennett. I am representing the Office of the Public Defender today. Ms. Lozano was unavailable and asked me to step in and speak on her behalf and on behalf of the agency. I do have several points that I think will clarify this conversation considerably. The first one, and I think Senator Case spoke to this, talks about the discretion of the judges in sentencing. In all of our criminal cases, the judge is the sentencing judge and the sentencing authority. Removing the prosecutor's consent to a 713-301 will put the discretion squarely with the judge, which is where all of our other sentencing, discretion, where that all belongs. And that is intended by our sentencing statutes. The prosecutor obviously has the opportunity to address the court as to their thoughts on sentencing, as does the defense, as does victims, and as does the defendant in a criminal case. I think that I don't want to put too fine of a point on this, but when the prosecutor has the opportunity to veto, as using Senator Case's word, a sentencing option. And that's what this is. This is an option to dispose of a case, just like many other options and many other sentencing recommendations. I think that one of the issues is, if we really delve into this, is it could be considered a separation of powers problem. And that, I say that because the judiciary, the judicial branch, the judge, is the person who makes final sentencing recommendations. With the way the 713-301 statute is written right now, that takes some of that away from the judicial branch and places it back with the executive branch. And so I think that is a very important thing to consider. And also, speaking to the prosecuting attorneys, the prosecuting attorney makes all the charging decisions, and that does not change. They make sentencing recommendations to the judge. They are very much involved, as Representative Oakley said, they are very much involved in plea negotiations. In fact, it is the prosecutor who has all of the authority to offer a plea agreement to a defendant. Removing this does not reduce their ability in any way to represent their constituents and to make fair and appropriate plea negotiation offers to defendants, nor does it remove their ability to argue an appropriate sentence in front of the judge. So I think that, that's also very important to consider. It's also important, and I think it was Mr. Chairman Olson that talked about the rights that are lost upon a conviction of a felony. In addition to the ones that we've already talked about, a person loses their right to vote, they lose their right to hold public office, they lose their right to sit on a jury. Those are all rights that are lost. In addition, and they also lose the right to be an elector. The firearms rights, that is a federal law, and it is also lost upon conviction of a felony. It's important to note also that firearms rights are also lost upon a misdemeanor conviction of domestic violence. So those rights are lost upon conviction of that one misdemeanor and any felony. A 713-301 disposition, it allows a person to prove themselves. What it does is a first offender statute. And sometimes I say this a bit tongue in cheek, but I think it's true, is I don't ask for a lot of 301 dispositions for people. I think they're very appropriate in certain instances. And sometimes prosecutors agree with that, sometimes they don't. But my thought on that is that a deferral under 301 or a deferral under any of our other statutes, and we do have a couple of others, but in essence, it is also a good deal for the prosecutor. And here's why I say that. Number one, a prosecutor is getting a guilty plea. They are getting that plea. That person has gone in front of a judge and pled guilty to that charge. They are placed on probation, and one of two things is going to happen. That person is either going to be very successful on probation. The prosecutor in that instance looks like a hero. They look like a great guy. Look, we gave this person a second chance. They've done all these wonderful things with their life. We're not going to enter that conviction. That is exactly what we're hopeful for. The other side of that coin is a person may violate their probation. They may commit a new crime. If they commit a new crime, then the prosecutor has the option of going back, revoking that probation on the first one where they got the deferral. And if they can prove that, if the second crime or this probation revocation is proven, then they get that conviction and the entry of the guilty plea against the person. So they essentially get a conviction on a preponderance of the evidence standard. They don't have to go back and prove beyond a reasonable doubt that that person committed that first crime because the person has already pled guilty. All they have to prove is that they have violated probation. So for a defendant, it is a very fine line between, and again, I don't much care for cliches, but a deferral to a defendant is very often just enough rope to hang themselves. They are either going to do very, very well and everybody's right and it was great, we gave them a second chance, or they're not. And then they're going to be convicted of that crime, get their probation revoked, go back in front of the judge and get sentenced on that initial crime. So it's not necessarily a free pass. And I want the committee to understand that very clearly, that sometimes it's great and it works out great, and sometimes not. So it's not necessarily a great deal for that person. It is absolutely an opportunity for them to show the court that they are going to do well. I also want to point out that I think it's been brought up, and Ms. Lozano talked to me too about making sure that this committee understands that an expungement is not necessarily a cure. Person is convicted, they don't get a 301 because the prosecutor won't consent, for whatever reason. Expungement is available, but there are some things that happen as a result of that conviction, because in order to get an expungement under at least two of our laws, 713, 1401, 1501, and 1502. 1401 does not require conviction, but 1501 and 1502 do. And there is a waiting period for that conviction. So if that person is convicted of a crime, all of the things that they lose, all of their rights very often their job, sometimes their housing, sometimes federal benefits, all of those things are lost. So there is a very long period, I believe for a misdemeanor, it's 5 years, and for a felony, it's 10 years. So that's not the same. It's not necessarily a cure. There is a long wait, and I guess the effect on the person's life happens during that waiting period. It happens immediately upon that conviction. So I'm hopeful that the committee doesn't say, well, they can just get it expunged later on, because yes, that's true, but the harm happens beforehand. And some of these, I believe, will answer Representative Oakley's questions, but I'm certainly happy to answer her specifically if I don't cover it in this last point. And that is that unfortunately, the 713-301 deferral has become a political tool. There are counties, and right now I serve as a public defender. I've also had a private practice criminal defense firm, and I've served as a public defender on a contract basis and prior to that. So I'm speaking with a fair amount of experience, and I've practiced all over the state. In most of our counties, I have actually had cases. I don't believe that this statute was ever intended to be a political tool. Unfortunately, it has in some counties. And I believe that we could fill several days of testimony from defense attorneys and from defendants themselves of anecdotes about abuse of the 301 statute. I think that we have very good prosecutors in this state, and I don't say this with any intent to disparage any of them. I think some of them are very, very good, and I've been able to work successfully with most of them. However, the problem with the 301 is that it is not, it's not equal. And then we run into a problem with equal access to justice. And it should not matter. There are some prosecutors that absolutely never agree to a 301. And there are other prosecutors that are, they do agree to 301s, but they are, I guess, very careful about who they agree on. And that's fine. But it should not matter if a person gets a DUI in Albany County or in Carbon County. The sentencing options available to the judge should not be different. The judges in both of those counties, or in all of our counties, should have the full array of sentencing options in front of them. There are counties, and I can talk all day long about abuses of this, but there are counties that will not agree to a first offender statute, treatment under 301. And it shouldn't matter if a person commits a crime, and I'll use a DUI for example, simply because that's a mobile crime. It can happen anywhere on our highways. If a person has a DUI, and oh my gosh, if you would have just made it 5 more miles into Albany County, I probably could have talked about a deferral with a prosecutor. That's where the abuse comes in, and that is the problem. Is that it's an equal justice, it's an equal access issue. And Ms. Oakley's absolutely right. It does require guilty plea, and that is part of the statute. And certainly no one is asking to change that. And a deferral under 713-301 is something that's absolutely part of plea negotiations in most counties. And that is not something that we're talking about. And the prosecutor absolutely has the ability to stand up in front of that judge and explain to the judge why they do not believe a deferral is appropriate. So that takes nothing away from their ability to argue. What it does is it allows the judge to be in charge. It allows the judge to be the person that makes the decision as to how a person should be treated. And that's how it is in every other part of our statutes with regard to the deferrals. We do have another deferral under our drug statutes for a first offender for possession. And that one is in the purview of the court. And what it would be appropriate would be if this one is also so that the discretion on how a person is sentenced is squarely with the court and not it doesn't take sentencing and put sentencing in the hands of the executive branch. It keeps it in the judicial branch where it belongs. And one other point, I believe, I don't remember if it was Senator Case or Representative Oakley that brought it up, but there was something mentioned about misuse and having people plead guilty when maybe they aren't. And what I will tell you, I don't want to elaborate too much on that, but just that there are a lot of reasons that people plead guilty to crimes. Sometimes they plead guilty simply because they can get out of jail. And I know that this committee heard a great deal of testimony and evidence a couple of years ago when the committee was considering the criminal justice reform. So I'm not going to go too much into that, but there are a multitude of reasons that a person will plead guilty. Sometimes they are guilty, sometimes they're not, but sometimes they need to get on with their lives. They need to get out of jail. There's a lot of reasons. And sometimes it's because there's a deferral being offered. It's an opportunity to avoid the risk of trial. Trial is arduous. It is difficult. It is incredibly risky for a defendant. And sometimes people just don't want to take that risk, and they will take a guilty plea. So hopefully those are answers to the questions that Representative Oakley had and your question, Chairman Olson. And I would be happy to answer any additional questions.
Committee, Representative Oakley.
Thank you, Mr. Chair. Good afternoon, Mrs. Bennett. Mrs. Bennett and I graduated law school together. So I guess it's kind of the same thing, but it's all this discussion. So two things. I heard, first of all, I guess I want to discuss this relevance, what you kind of ended with. This whole, they plead guilty to something that they shouldn't have. I don't understand the relevance of that to this conversation, because if that's happening, is that not on the defense attorney and the defendant? I just don't see how, that plays into this conversation. And then you ended with, because trial is difficult and arduous and hard for them to go through, but taking this away so that the prosecutor and defense attorney cannot, and the defendant cannot have the guarantee in their hand when they go in front of the judge before sentencing, when they plead. I don't see how that wouldn't make it so that they're more likely to go to trial.
Ms. Bennett.
Thank you, Chairman Olson. Representative Oakley. And I think that you're right in that it's not necessarily all that relevant, but I believe it was Senator Case that talked about someone pleading guilty when maybe they weren't, or just pleading guilty to get out of jail. And that's the reason that I addressed his concern about that. And with regard to sentencing, there are no guarantees. The judge has the discretion, even with a plea agreement, for a deferral. The judge has the final discretion as to whether or not they take that plea agreement or not. It's a tremendous risk to the defendant. My comment about trial was simply because Senator Case mentioned people pleading guilty that maybe shouldn't or maybe should go to trial. And that decision, whether the defense attorney, whether anybody thinks that they should, that decision is 100% within the rights of the defendant. And my point was simply that they do things for a lot of different reasons. Those reasons are their own. The defense attorney and the prosecutor to a certain extent, but the defense attorney's job is to put all of those options, including this one, if it's available to them, whatever the plea negotiations are, the risks, the benefits of pleas, the risks, the benefits of trial, all of those things are placed before the defendant. And it is the defendant that makes the decision whether or not they plead guilty. And so Representative Oakley, my intent was simply to address the comment that Senator Case made. And hopefully that answers your question.
Yeah, I addressed that, Mr. Chairman. I can understand now that I was certainly misunderstood. You guys, I'm in out of my wheelhouse, but my understanding is that when you are charged, you're often charged with a series of things. And there are different counts or, what have you. And that it kind of works out in the plea agreement, what you end up doing. And so it's kind of that how vast things you plead guilty to in the plea agreement versus what you end up with is more what I was referring to. I do understand this only applies in the case of guilt, and I do understand that. So I hope that's helpful. I didn't mean to cause so much discussion here.
No, it's helpful. Thank you, Senator Case. So Ms. Bennett, I want to kind of maybe bring in an example then to that scenario. So, and because I think there's a lot of procedure here, and I think all the lawyers in the room are kind of fast forwarding through the procedure. So I just want to make sure that everyone understands the procedure. And the other thing that's always, I guess it's confusing to me, but I understand it as a lawyer, but as when I put on my layman hat and I look at the statute and it says end of the state, and the state is what's being crossed off. I mean, what we're talking about is the prosecution. I find it interesting because I do think that the court is the state in a lot of ways too. I think that obviously the public defender is the state. So I think, and I say that with the court, meaning the court has a responsibility to be obviously a decider of fact in the case. But I do think, and most judges I believe would say this, they in every case that they have the public's interest in their mind as they pursue cases. So, and I want to make sure I understood what you said, because I think you said when we eliminate the prosecution from having the veto or trump card, we don't eliminate the prosecution from the discussion of the deferral. Is that right? The prosecution is still able to advocate for a deferral, make arguments or against a deferral, either way. And ultimately, if I understand this right, all it's doing is saying the court, it's empowering the judge to make the decision and always be the decider, which I think you said was consistent with all other. This is the unique scenario, the only deferral where we rest it in the prosecutor's hands versus the judge's hands. Is that right? Is that an accurate description of the procedure anyway?
Thank you, Chairman Olson. Yes, and I think also I may be mixing things just a bit in that I've talked quite a bit about plea negotiations, and I've also talked about a little bit about trial and that sort of thing. And you're correct. It does not eliminate the prosecutor from that discussion at all. In any other case, in any case, when a person pleads guilty to a crime, they can do that they can just go in front of the judge and plead guilty without any type of plea negotiation at all. We call that a cold plea. So there's no agreement, that you go in front of the judge, both sides argue what they think is appropriate. And we do that from time to time when a person doesn't want to go to trial, or they just simply, we just can't come up with an agreement. It happens. The other aspect of a guilty plea or a no contest plea, but we're specifically talking about a guilty plea, is when there are plea negotiations, the prosecutor and the defendant have come up with what they believe is an appropriate disposition of the case. And then you go in front of the judge and the judge makes the final determination. A plea agreement is no guarantee of an outcome. A plea agreement is simply a recommendation to the judge, to the judicial branch, to the court. So the state will always have the ability to argue in front of the judge at sentencing as to what they feel is appropriate, whether that person is just pled guilty, whether they've been found guilty at trial, or whether there's some sort of plea. The state always has the opportunity to argue for what they think is appropriate, as does the defense. The court, and Chairman Olson, the court is the decider of fact in a bench trial. It is the jury that's the decider of fact in a trial. But the court does evaluate what's in front of it. And certainly the court has the ability to evaluate all the information at sentencing, which is what we're really talking about here. The court is the judiciary, the court is the judicial branch, the state or the prosecutor is the state, and the defense is charged with defending that defendant's rights. And so everybody has a role to play, and that's very important. And you're correct, it is unique to the 713-301 in that, and here is the crux of why this legislation is so important, is that a 713-301 is the only statute where if a person simply goes in front of the court and pleads guilty, a defendant or a defense attorney cannot put that deferral option in front of the judge unless the state consents. So unless there's a consent from the state right now, the court does not have that option. The court doesn't have that ability to look at every single possible sentencing option in front of it. So it is taking that sentencing discretion away from the court, because the defense can't even argue for it unless the state consents. So all we're really asking the legislature to do is to put all of that discretion squarely within the purview of the judge, which is where it is in every other situation where a judge is faced with sentencing a defendant.
Ms. Bennett, you just said something that is, I think, very important for the discussion, because we've used some layman terms like veto and trump, and I'm going to pull those back, because I feel like I misuse it if I say that the prosecutor has a veto. What you just said is that without the prosecutor's consent, it doesn't even come before the judge for consideration. A veto would be the opposite. A veto would be the judge makes a decision and the prosecutor says, you know what, nope, not going to do a deferral. This is giving the state or the prosecutor all of the power to decide if the option is even in front of the judge to even consider. So the discussion can't happen without the prosecutor. Whereas with this legislation, what happens is the question can come before the judge and everyone can discuss it, whether the prosecutor gives permission or not to discuss it.
That's absolutely correct, Chairman Olson. Thank you. And you said it far more succinctly than I did, so I appreciate that. But that is correct, because the way the statute is written is that it says the consent of the defendant and the consent of the prosecutor. The court can't consider that without that consent, is the way that statute is written. And so all this really does is give that one additional sentencing option to the judge, which is exactly what the judge has in every other instance. This is the only one where it requires the prosecutor's consent for the court to consider that option.
Thank you. Other questions for Ms. Bennett? Representative Oakley.
Thank you, Mr. Chair. A couple of things. You mentioned separation of powers, Mrs. Bennett. Actually, the Supreme Court has reviewed separation of powers when it comes to a 713-3 deferral. Isn't that correct?
Ms. Bennett.
Representative Oakley, I would have to research that. I'm sorry, I don't have that case in front of me or a case in front of me. And simply, the way I would respond is that the legislative branch has given us this statute 713-301, and with that, because the legislation is what it is right now, then no, it's not a separation of powers issue the way the legislation is right now. However, what it does, and I would suggest that it is taking sentencing discretion away from the judicial branch and placing that with the state.
Representative Oakley.
Thank you, Mr. Chair. So I heard the word abuse again, and I find it interesting that, so that's in regards to a prosecutor or prosecution office reviewing a case and not finding that person an appropriate candidate for a 301. Couldn't the judges, and don't you actually see it, that the judges are every bit as disparate in treatment? I mean, we are talking, it's human beings in the statewide system, or what is the thought that that judges, that you wouldn't get that, you used in Albany, and I assume probably thinking of Carbon County example, but what would be the difference between judges acting every bit as disparate?
Ms. Bennett?
Thank you, Chairman Olson. Representative Oakley, I don't think that this is the conversation for whether or not, you know, our judges are going to do different things in different counties. They do. And whether I don't know that I would characterize that as abusive or disparate treatment or whatever. But what this does is it removes one more layer of unequal access to justice. And then it is in the judge's hands, and judges have the authority to sentence the way that they feel is appropriate. And some judges feel differently about that. We trust our judges. We put them, you know, they go through a rigorous selection process. We put them on the bench because we are asking them to make those calls. And it is the judge that has that discretion. And I think that's the entire point, is that in this particular instance, it is not the judge that has the ability to do that. It is, it can't even come before the judge until the prosecutor consents. So what we're asking to do is just remove that layer of I guess, unequal access to a statute that's on the books. So I can tell a client in one county, yes, you have the opportunity to take advantage of all of these statutes. But in another county, I can say, well, gosh, sorry, this county attorney has decided that this statute simply doesn't apply in their county. And that is where the problem is. And what is in front of our judges, that's a different conversation. The judges do have all of the discretion in sentencing, as they should, as the judicial branch, and that's what we have placed them on those benches to do, is to exercise that discretion and to sentence the way they think that they should. Those judges have to answer for that. Our judges stand for retention, and so if there is some severely disparate treatment between counties, between jurisdictions, then that is something that the judge takes responsibility for.
Thank you, Ms. Bennett. All right. Let's get some other agencies and associations, and I've got some general public that want to testify on this bill too. So thank you, Ms. Bennett. We do have the Attorney General's office here, but I assume you're here for the other bill. You don't want to answer constitutional questions. Okay. All right. All right. No. All right. All right. Let's go ahead and bring Mr. Barron. Mr. Barron, we're going to bring you in and hear from Mr. Barron. Go ahead and, go ahead and introduce yourself. And if you represent an organization, let us know. Or if you're testifying on your own behalf, let us know.
Thank you, Chairman Olson. My name is Joseph Barron. I'm the Crook County and prosecuting attorney. I've been a prosecutor for all but 6 months since 1986. I've been the elected county attorney in Crook County since 1991. I'm here on behalf of the Wyoming County and Prosecuting Attorneys Association, who oppose this particular bill and the proposal to eliminate the state's right in this particular statute to whether or not that requires the state's consent for somebody to get a deferred, what we call a deferred prosecution, in that, in a particular criminal case that falls under the statute. Now, I want to start out with, I've submitted a document to the Judiciary. I sent that out yesterday or the day before, whenever we're going to talk about it then. So that has some of the things that I wanted to talk about. But first of all, I think we need to start with the fact that a deferral has not been around that long, and the state's right on this thing was granted by the legislature in 1987 to grant the right to require the state's consent before somebody is given a deferred for a misdemeanor and or a certain felony offenses. Let's understand this. This is an extraordinary remedy that is available. And I've heard it said that harm happens beforehand to a defendant. But what we're talking about here is harm has occurred. There's been a violation of the law. Let's not forget where we start at in this case. Somebody's house has been burglarized, somebody's car has been stolen, some other law has been broken, and that the legislature deems appropriate to say is a violation of the law. And that's where we start in this particular issue here, is there's already harm. There's harm to society, there's harms to victims, there's harm to people here. Let's not forget, we seem to be focusing here on defendants' rights and what's good for the defendant. But let's look at what's happened in the past, what's good for victims, and what's good for society here. Now, our system of government, and it is a system of government that we've had for well over 200 years, is made up of three branches of government. There's the judiciary, there's the legislative bodies, and there is the executive branch of the state. And as a state that's used in that statute, the county attorneys represent the state in this matter. And the legislature passes a law they expect us to enforce, and we enforce that. The legislature decides what remedies and what tools courts can use for sentencing options. You hear it every day. We need a program for alcohol abuse or drug abuse, or we need this program in the penitentiary, or we have the youthful offender program. All of those things are created not by the court. The court can do nothing without the legislative body determining what they can and can't do and providing the finances for all of these programs and everything to exist. So just like this statute, a court doesn't have a power to grant a deferral unless this legislative body gives it to them. And what we really look at here is our system of government is built with checks and balances. And there's checks and balances between the different branches of government. And this, frankly, is a check and balance against the courts. And it's also a check and a balance in representing the people that we get elected. The only person within that room, in that courtroom, that really is elected is a county attorney. Judges stand for retention. They are not answerable directly to the people. They stand for retention. Nobody runs against them. And for example, in the case of the county attorneys, as it was stated in the earlier hearing, it's a lot easier to get rid of the county attorney if they're doing something inappropriately or if the people just decide to do that. In the past 6 years, there's been 20 new county attorneys that either been elected or appointed in the state of Wyoming out of the 23 county and district attorneys that have been presented here. So just want to understand that when we talk about this thing, is we're answerable to the people, and the people are there. And if the people of this particular county decide to elect somebody that says, we're not going to give deferrals, we're going to stand up for victims, we're going to do those things, then that's the people's right and the people's choice in this particular thing. And the society of that particular county and where we live. The other thing that I want to mention here is this, is that, and I've heard this stated in your committee before, but there are unintended consequences in this matter. So if you get rid of the state's ability and requirement to consent to a deferred, you may somehow think that that's going to be, yes, judges are going to be granting more deferreds. But my true belief is there will be less deferreds. There will be less deferreds granted. And the reason for that, I believe, is this, is because if the way the law is now, it takes three entities, the defendant to consent, the state to consent, and the judge to consent to this. There is certainly the political capital there that community, if all of those people agree to it, that's palatable for something to go on in that particular community to do that. And if you leave it to a judge, and I would venture to say, you know, as it was said in the previous hearing, is that it's saying there's 23 people here that have the ability to abuse this system. And when I don't know how many judges there are, but there are more judges than there are county attorneys that have the same ability to abuse this thing one way or the other. Abuse is I don't think abuse is the proper word. I think the proper word is to exercise their discretion on that. And since we're all individuals, one decision is just the same as another. Now, I want to talk about particular things that we've done here. And we've heard this too, that this is a second chance law. Well, our law has so many second chances built into it. By the time somebody gets to a deferred, I'd venture to say it's a fourth or fifth chance and not a first chance or a second chance. We have diversion programs throughout the state in offices. We have officers that grant discretion in particular matter. We have juvenile courts that keep things off records. The legislature has passed expungement laws for certain felonies and certain nonviolent felonies. You have automatic restoration of voter rights on this. You're considering a bill to reduce the expungement from 10 years for felonies to 3 years for misdemeanors, down to 5 and 3 years. All of these things already exist within, and these have all been created since this right for the state to require the state to consent to a deferred have existed. So what I really want to get that, I don't believe that be careful what you wish for, because you may get it and it may not have the same results. The other thing that can happen here is that you're not getting rid of the right to do that. One of the things that can happen now, as was stated, is that the state has the ability to file charges, and nothing changes that particular ability to file those charges. And there's nothing that prevents, in a case where there's one charge could be filed. Usually there's more than one charge that can be filed in most cases. Now, the one thing that I heard that was stated here, and I think it needs to be clarified to the people on the committee, is they say that the person has pled guilty. This is the first time they admit their fault. They come in and they plead guilty. But that's not what this statute says. If you pull the statute and you look at your statute on page 1, it says under line 14 through 16, if a person who's not been previously convicted of a felony is charged with or is found guilty of or pleads guilty or no contest to a misdemeanor. So what that means is that this right that's in here not only is for somebody that walks in the door and pleads guilty, but this right also exists for somebody that goes completely through a trial, doesn't admit to anything, goes through the trial, forces the witnesses and victims to testify in the matter, and the state to expend resources, for the court to expend resources, and then make a request for a deferral. And it doesn't give the state any recourse not to consent to that. If this is truly a second chance for somebody that's going to be, they need a second chance and they're really sorry for what they did, they come in and admit, and they do all those things, then in that particular case, then we need to change this law. And also on page 2, line 8, it also talks about the same thing, without entering a judgment of guilt or a conviction. The conviction occurs after a trial. And so, and some will argue that, well, that's a trial tax. You're going after somebody that you're not allowing something because they've forced the state to prove their case and a person from exercising their rights. The fact of the matter is admission is the first thing for accepting responsibility for your behavior. And myself as a county attorney, I've lived by that philosophy. If somebody is willing to take account for their actions, obviously they should get credit for that. But if somebody is not willing to do that, then there are consequences for that. And this body should not change this particular law in this case. And the other thing that you're doing, and it was argued in the other matter, that this is somehow save money for the state. That has no bearing. And the simple reason for that is this, that if a judge disagrees with the county attorney's failure to consent to a deferral, the district court judge can always put somebody on straight probation. They can always do that. So that has no bearing whether or not it's going to cost the state any more or any less in the matter. So I would just ask you to take a look at this. I don't want you to, Senator Case is correct. This is a philosophy where the state should be on this, but it just seems to me that the state ought to be on holding people accountable for their behavior. And the state, as we talked about before, is generally almost always know more about this particular defendant than anybody in the room. I would suspect that you're going to hear further testimony about, as we did in Senate Judiciary, about a particular case and how this particular thing happened. And I would just ask to reserve the rest of my time to address that particular case if it's brought up, on the reasoning on that by that particular county attorney not to grant a deferral in that matter, Mr. Chairman.
Questions for Mr. Barron, Representative Williams?
Thank you, Mr. Chairman. Mr. Barron, just curious if you can elaborate a little bit more about the role that this bill plays and how it might interfere with the Victims' Bill of Rights and the role that the state, well, the prosecutor would play in that process when it comes to obtaining criminal history and so forth.
Mr. Barron?
Chairman Olson, Representative Williams, one of the things that happens in this particular matter is that, first of all, obtaining a criminal record. Okay. Criminal records are kept in the state of Wyoming through two systems. One's called YCGIS, which is a state system, and the other is called NCIC, which is a federal system that we include stuff on. The only people that get into the NCIC system are the people that are actually arrested and booked in, and there's a set of fingerprints on that particular case. So somebody that was arrested for burglary, let's say in this particular case, if they were arrested for that, their arrest record would show that they were arrested. It would also show that they were charged with this particular offense. It would then show that they were granted a deferral under 713-301. So in the future, and that record exists and remains. So in the future, I can check, as I do, to determine if somebody's eligible for a deferral. Well, have they ever had one before in the state of Wyoming here, or some other state, and so that they're eligible for this. And so I'm able to find that as a prosecutor relatively easy to find that. As it relates to victims' rights, Representative Williams, the victim in the case, in any case, always has a right to address the court. They're notified by the prosecutor's office, and they're also notified for a victim's impact in a pre-sentence investigation report that's prepared by the Department of Corrections in most felony cases. Although there's a recent change in the law that allows us not to do that every time, but in misdemeanor cases, it's left up to the county attorney to do that.
Thank you, Mr. Barron.
Any other questions for Mr. Barron? Seeing none, thank you, Mr. Barron. Appreciate your commentary today. Anyone else in the room wishing to testify on this bill?
Mr. Chairman, would it be all right if I just deferred to Jeff Stanbury and Devin Peterson? I could just let you know that the Lawyers Association section for the bill, and I have a couple of good questions that I think we're not, but
Thank you, Ms. Shanner. I do have, I think I've got four lawyers lined up in the virtual world. So we'll start bringing them in, and that'll be just fine with me. Mr. Stanbury. And then we'll go with Mr. Stanbury, number one, Ms. Devine, number two, number three, Terry. And then I do have, let's go ahead and put Devin, let's admit Devin Peterson as well. And then we'll go to Devin, number four. All right. Jeff, you're on deck.
Thank you, Mr. Chairman. Ladies and gentlemen, my name is Jeff Stanbury. I'm an attorney up here in Fremont County, Wyoming. I practice in Lander and Riverton, and I do practice in the area of criminal defense. A couple of you are my colleagues, and I regularly have the pleasure of practicing with and against Representative Oakley. I'm interested in this bill because I think it will produce a positive change in Wyoming law by not just making the treatment and disposition of sentences equal, regardless of what county you may reside in, but afford defendants who are in large part young offenders and first-time offenders the opportunity to both prove themselves and perhaps rehabilitate themselves with extended due process that's not available under the current law. I'm going to try and be brief. I don't want to try and hit on what Ms. Bennett touched on, but just to kind of give an overview as a more simplistic approach, the 713-301 statute is a mechanism that is an awesome opportunity. It provides both a carrot and a stick approach to a sentence for somebody who is either found guilty, pled guilty or pled no contest to a charge. It allows the court to place that defendant on a term of probation under certain terms and conditions that both adequately punish a first offender or a youthful offender, and then upon successful completion of that probationary term, that charge can be dismissed, i.e. the offender is not saddled with a conviction for the rest of their life for what is in all likelihood a one-time mistake. Contrary to the testimony we heard, by and large, nearly all of my 301 candidates, it's not their fourth or fifth bite at the apple. Most of them, it is their first brush with the criminal justice system. The carrot and stick approach provides a unique opportunity because, in essence, we don't just have the stick hanging over their head that they could go to jail if they reoffend or violate their term of probation. It affords them incentive to change and to demonstrate to the court that they have proven themselves and completed all of these terms and conditions, rehabilitation, and genuinely make themselves a better person than when they went into the criminal justice system once they come out. As discussed, it is available really for only nonviolent felonies, first offense misdemeanors, and domestic violence. There are significant Second Amendment implications that go along with this. As discussed, person loses their Second Amendment rights upon conviction of a felony and a domestic violence conviction. Thus, our kids in Laramie that run down to Colorado and make that mistake to bring up a felony amount of marijuana, in large part, if they're not afforded that first offender status in certain counties, could be saddled with the conviction and forever lose their firearms rights. There was some testimony in the Senate hearing regarding the expungement and that a 713-301 could disqualify somebody from having that conviction expunged, and the expungement can be used to restore those Second Amendment rights. I think that's a very dangerous position, mostly because the other states have looked at our expungement statute, and because it allows law enforcement agents to utilize those prior convictions for the purposes of background checks and the like, that it does not fully restore that firearm right. The firearm prohibition is a federal prohibition under 922G, and it is unknown whether our expungement statute effectively restores that right. 713-301, however, the conviction is never entered provided the person is successfully completes that probation in those terms. But there are additional due process rights, and I think this goes to the heart of the matter as to whether we allow a judge or a prosecutor to make this determination. With regard to the state's consent, in order to essentially present your defendant as a qualified defendant, you have to have an audience with the state. I am fortunate up here in Fremont County, in large part, our county attorney's office has granted me audience. However, I've had numerous experiences, including prior to our current administration up here, where the very first time I get to speak to a county attorney to see if they'd be willing to allow a first offender to proceed under this statute is at a pretrial conference. The opportunity to really showcase who my person is, who my client is extremely limited under those circumstances. If we contrast that by placing this mechanism in the hands of the court, it affords the offender numerous due process rights that were not afforded previously to that. At sentencing, an accused or a defendant is allowed to introduce evidence, subpoena witnesses, and have others testify as to why they are a qualified candidate and should be allowed to proceed under this statute. If it's left to state consent, it depends upon whether that audience is granted. And I can tell you in my career, I have had that audience declined in numerous circumstances. Thus, the county attorney is essentially making this decision based solely upon the criminal background and the offense that is on paper. They've never had the opportunity to meet with my client. They've never had the opportunity to get a real perspective as to who this person is and whether they can be a successful candidate with regard to this statute. In the case of young offenders, our kids make mistakes. I've made mistakes. Most people have made mistakes. And it gives that kid an opportunity to really demonstrate who they are if they do not have that audience. But yes, we are talking about equal treatment across the state. That equal treatment goes through prosecutors' offices and it will go to the court. But the protection that is afforded, that is not currently afforded right now, is the fact that you have this process to allow an accused or an offender or a defendant to introduce evidence that is also subject to judicial review, provided that under an abuse of discretion standard. Now, of course, our judges are going to, in large part, be granted a lot of discretion in sentencing. But whether there is equal treatment afforded under that statute is now granted another veil of review. As far as the state goes, the role of the state does not change. As I've said, Representative Oakley and I have had numerous cases against one another. She's probably notched more W's in the column than I have when we faced off. But I am still going to seek the role or the consent of the state, because their agreement in allowing my clients to proceed under 713-301 is a valuable tool in persuading the court that my client is an adequate candidate for this treatment. They have the opportunity to address the court just like we do and advocate for the people of the state of Wyoming. And I know that most of our county attorneys are effective advocates for their clients. It changes nothing except the audience and the presentation that we get to make on behalf of our clients, that they are suitable candidates before we forever saddle them with a conviction that's consequences may never fully be expunged. This is, as they've stated, it's not a new mechanism. I do believe there was one inaccuracy in terms of the deferral statutes. I believe that 35-7-1037 is the only statute that allows us both to argue and for the court to grant it without prosecutorial consent. There is another deferral statute, 720-103. I do believe that statute does require prosecutorial consent. However, that statute's a little more messy in terms of its qualifications. This would allow a defendant to advocate for treatment for such a conviction without prosecutorial consent under 713-301. Again, I appreciate the opportunity to speak in front of you today. I think that this will make our sentencing decisions far more educated and tailoring a sentence that is more likely to adequately punish a defendant and create rehabilitative incentives for one to abide by, if we are allowed to fully educate everybody on who this client is and the offense that they've been accused of. Thank you.
Questions for Mr. Stanbury? Oh, Representative Oakley. So surprised.
Thank you, Mr. Chair. Hello, Mr. Stanbury. I have to say, I really am interested in this argument. It's actually shocking to me. The idea that it's a limited opportunity to discuss the case with the prosecutor, so you need that full vet in front of a judge and hours that you and I have spent on the phone discussing a case. Isn't it true? I mean, the prosecutor has talked to the victim, has talked to law enforcement, knows all the evidence, discuss it for months. And then afterwards, you're talking about getting a 30-minute, 45-minute sentencing hearing. I guess my question to you, I don't know. I think I literally am hearing a 180 from reality of which is the limited opportunity from you. And I think that's so key in understanding why this is not a better option. So I guess if you were saying before it used to be a limited opportunity, but I just don't think that's the way criminal prosecution and the discussion of cases goes.
May I respond?
Oh,
I'm
yeah,
sorry.
I think that was a question. Mr. Stanbury.
Ms. Oakley, Representative Oakley, your office, as I stated in my statements, has always been a great office to work with and has granted me a significant audience. That experience has not been my experience in other counties. I have literally walked into a court hearing and not had a single phone call returned from county attorneys. I haven't had a discussion with some of these attorneys until we're walking up to the podium with respect to what the status of the case is. And some of that even occurred in this district before our current county attorney. It does happen. It does happen. And my experience across statewide, it differs depending upon which county we go to. And I think one of the vulnerabilities in terms of the equal treatment is some of our larger counties, such as Natrona County and Laramie County and Campbell County, where I don't want to discount Fremont County's caseload. It is high, but some of those counties have even higher caseloads and their time is limited. That opportunity is limited in those cases because maybe those prosecutors are a little bit, they're saddled with so many different hearings because their caseload may be higher. This affords all of us the opportunity to present our clients, introduce evidence, subpoena witnesses, allow the victim to speak, and educate our judge. I hope I answered your question.
All right. Thank you, Mr. Stanbury, for testifying. Got 3 more on deck. Got 20 minutes. If we leave the committee with just 5 minutes to consider this bill, that leaves 15 minutes, just under 5 minutes for each one of you, including questions. So let's maybe we can aim for that. Did I say Ms. Devine was next on deck?
You did indeed, sir.
All right. Let us know your first and last name and if you represent an organization, and then let us know what you think we need to hear.
Thank you, Mr. Chairman. My name is Linda Devine. I am an attorney in Laramie, Wyoming. I work for myself, and I'm here today. First of all, I was elated to find out that this bill was coming over here. As a defense attorney, well, first of all, I can just say this. The 2 previous speakers, Ms. Bennett and the other defense attorney, were quite eloquent, and I share all of their thoughts and positions with that. For me, as a criminal defense attorney, I just want a level playing field to be able to speak to the judge. And I feel like that is what is missing in this, the 7-13-301. And I'm hearing the prosecutors talk about, that they're representing the community, and if the community elects them knowing that they don't support this, then that's their position. I think a lot of community members don't even know half the time if a prosecutor supports first offenders or not. I think to me, the important thing is what we have. I'm representing a defendant. It is my job to present to the court the reasons why I think my client should be considered for the first offender under 7-13-301. Equally important, the state also has that opportunity to argue against it. The courts, the judges are provided with broad discretion. The gentleman earlier who's with the Prosecutor Association talked about, well, what if the judges aren't providing equality? There's another method for that, and it's called an appeal. If a judge abuses his or her decision, his or her discretion, we can appeal that. So I'm here today just urging you guys on behalf of all of my defendants, just give us the chance to present our case to the judge. I always provide a sentencing memorandum to the judge. I talk about the sentencing factors that judges are to consider, and one of the main ones is rehabilitation. And if I can show my judge that my client has been doing everything he or she could since the initial charge to show that they are making changes and that they are rehabilitating, then the judge has the judge needs to be able to hear that and hear the reason why my client should be considered and receive a first offender. The other folks have already said everything that I believe in, so I don't want to keep rambling. I appreciate all of you taking the time to listen to this, and I would urge you to vote this yes. Thank you so much.
Thank you, Ms. Devine. Questions for Ms. Devine? All right, we appreciate your testimony. Terry, you are next.
Good afternoon, Chairman Olson, members of the committee. For the record, my name is Terry Armitage. I'm with the Sheriffs and Chiefs Association, and I want to speak in opposition to this bill. By way of background, I've been an attorney for 35 years in Wyoming, born and raised here, got my education here. Approximately half of my career was spent at the Attorney General's office in the criminal division. I've been a special prosecutor, an appellate prosecutor, worked at the DA's office for a period of time as well, and worked with law enforcement throughout my career. Law enforcement is interested in the county attorneys, the prosecuting attorneys, being able to do their job and exercise their discretion. Law enforcement's out in the trenches, they make the arrest, develop the case, get it to the county attorney. The county attorney then uses his discretion to bring charges. And part of that discretion is whether or not a 301 deferral is appropriate. And I'll give you an example. Senator Case talks about the veto power of the prosecutor, or if we call it refusal to consent, whatever. When I was at the DA's office, there was a young lady I had charged with a felony. She had a clear background. She unfortunately was with a family who was in and out of prison constantly. Almost every member in there was somehow involved in criminal activity. And I thought she would be a good candidate for a 301 deferral. She maybe could turn her life around, go in a different direction from her family. And I made that offer to the defense attorney, and he got back to me saying, no, my client refuses, will not consent to a 301 deferral because in this family, it's a badge of honor to get a felony conviction. So the consent goes to both parties, and obviously the judge is the final arbiter on whether or not a 301 happens or not. Understand the 301 deferral is not an entitlement. It's a type of legislatively created leniency. And if the prosecutor thinks the person's a proper candidate and he'll agree, then they can go forward and go to the court and seek the deferral. The judge may or may not give them that deferral. If we take the prosecutor out of this three-legged stool, it's not going to stand up very well. And if the court has to hear every single 301 request by every criminal felon that is accused and wants a deferral, there's going to be a judicial economy problem. I got a lot of requests for 301 deferrals over the years, and the defendant just wasn't appropriate. Simple as that. I don't think there's anything out there that would indicate that a prosecutor is in any way abusing something if he doesn't consent to a 301. That's within his discretion. That's part of our system. What charges he brings is part of his discretion. I would suggest the only people that want the prosecutor out of this loop are those that are facing a felony conviction, that want the leniency. I would say that people of Wyoming in general would probably agree the system works just fine the way it is. So I would suggest that we take appropriate action to get this bill out of there and go on to something else. Thank you.
Committee questions? The only thing I would say, Mr. Armitage, is that, and this is more of a comment, is that one of your comments was about judicial economy if we were to allow all of these deferrals to move forward without using the state as the gatekeeper. And I would just, I would just caution a little on that, because your testimony would be on behalf of the judicial branch saying that they would have a judicial economy issue, but they're definitely not here testifying, and they won't testify on this because it's a policy question. But I have talked to my judges, and my judges see this bill a lot differently. I think they see it as an empowerment and a sentencing tool in their hands. So that's what I hear from judges when I talk to them. So I just wanted to make sure we get that out there.
And Chairman Olson.
Or maybe you can have a response, sure.
I was only speaking from the perspective of the prosecutors and the law enforcement that they work with. If the prosecutor's got to go to a hearing in every single case that he's handling to debate the 301, it affects his workload and his time. And if law enforcement has to appear at all of these same hearings, it affects the whole system.
Excuse me. Thank you for clarifying. I appreciate that. All right. I think any other questions for Mr. Armitage? Thank you for joining us. All right. Last one on deck, Devin, you're it. And maybe we got enough time to still consider the bill. So I think you're in good shape unless you decide to talk for 10 minutes. But please let us know your name, and if you represent any organization, then let us know what you want us to hear.
Thank you so much, Chairman Olson, and I will keep it brief. I'll try to stay under 5 minutes. I think a lot of what has been said, I don't need to cover again. My name is Devin Peterson. I'm a defense attorney in Wyoming. I'm a partner at Fleener Peterson with our main offices in Laramie. And I'll just jump straight into the judicial economy, or how is this going to tax the system? I believe that it would actually increase efficiency, and that when defendants do not have the ability to go to the court for a 301, it actually bogs down the system. And to be clear, how that would happen is in a case where the prosecutor will not agree to a 301, then there may not be an incentive for a defendant to take a plea agreement when they otherwise have a good case to go to trial, and you end up having trials where otherwise none would be necessary. And to Mr. Armitage's point, this isn't going to happen in every case. And I think the committee should realize that, which is, I believe the way that defendants would utilize this would actually happen in a very, very limited number of circumstances. And I'd just like to explain that quickly. As Mr. Stanberry said, we as defense attorneys are still going to do everything we can to get the state's agreement, because when we go to the court with the state's agreement, we have a much more likely chance of getting the 301. And so we're still going to try to get a plea agreement for a 301. And I would hope that the prosecutors, since their duty is to justice and not to any particular client and to do the right thing, even if this bill passes, would still agree to 301s in the appropriate circumstances. And that wouldn't change anything about how the prosecutors go about this. There will be the rare circumstance where our client is eligible, the prosecutor doesn't think 301 is appropriate. We think that there will be, and we think, and it's going to be a gamble, that the judge will go along with us, because in that circumstance, we might not have a plea agreement. And as the defense attorney, we'll have to use our discretion to say, look, client, the prosecutor's not agreeing, but you have the option of a cold plea, which means the prosecutor's going to object to the 301. We don't know what's going to happen at court, but I think this judge will do the right thing and give you a 301. So we're going out in there without any protection. And that's going to be a scary circumstance. And we're not going to do that all the time, certainly not in serious cases. So we're talking about this bill giving these defendants an opportunity in nonviolent crimes, in limited situations where the prosecutor and the defendant disagrees, and we give the court the final say. That's, as Ms. Devine said, all we're asking for is a chance in those very limited circumstances. We're still going to try to get those plea agreements. And to just sort of end all of this, we've talked a lot in the abstract. We haven't had a lot of specific examples. I know Mr. Armitage gave an example of a client who didn't want a 301 because of it was a badge of honor to get him a felony. I've never seen that. I've never heard that. Maybe that happened once, but almost everybody would love a 301, would love to be able to not have that felony conviction, not lose their gun rights, not have to check that box on employment applications, housing applications, student loan applications. And it's an incredibly valuable thing. But when we talk about the prosecutors and how they, what they analyze and how they go about it, there are good prosecutors, and they take everything into account, and including whether or not a candidate is an appropriate candidate for this. But let me tell the committee some way that this doesn't work as the system currently stands. You have two defendants, both are equally qualified. Neither one have a felony conviction. They're both the same age. Everything is exactly the same. One defendant, when they get caught with marijuana, goes in, the law enforcement confronts them, and this person, because they're, I don't know, a good person or a more worthy candidate, says, "You're right. You caught me. I was using marijuana. I gave some to my friends. I'm sorry. I've developed this, marijuana use. I know it's wrong. Please forgive me. I won't do it again. I want to change my life." Client B goes in and says, "You guys can pound sand. I know my rights. I'm not talking to you. I didn't do anything wrong. I want a trial. I'm not taking any plea deals." None of that. Okay. No attorneys are involved. Later on, we get the discovery. And in client A, who's under the statute and in the judge's eyes, a more worthy candidate for a 301, I've had many prosecutors tell me, "I'm not going to give you a 301 because we have a very strong case. Your clients admitted to having this. So I have an easy case. My case would take 20 minutes long. I would put on the law enforcement officer, I'll hit play, and the jury will convict him because your client admitted it." And I said, "What about all this talk about if you cooperate and if you tell us, that you did this, then we'll take it easy on you or things will go better for you." Under the current system, it's not true with some prosecutors. You get punished for that because the state is using the 301 process, not because of whether somebody's a deserving candidate, but whether or not their evidence is strong or not. And that comes straight from the defendant who is more deserving. And if this committee will pass this bill under those circumstances, we as a defendant can go to the judge and say, "Judge, my client deserves this. He did the right thing. He admitted right away without an attorney. He took responsibility and he deserves a 301. As the law stands right now, we can't do that if the prosecutor says, "I have a strong case. Your client needs to eat a felony conviction. Otherwise, I'll go to trial and I'll just get that conviction." So this bill would help to alleviate those problems. And that's my 5 minutes.
Thanks, Mr. Peterson. We're in luck, even if we have to consider this bill for a few more minutes, because the committee of the whole chairman is sitting to my left and they just can't start without us. So. Is it 2:15? Oh, wow. Mr. Peterson, I'm sorry. Sorry, to get back on point. Committee, do we have questions for Mr. Peterson? No questions? Thank you for your testimony, Mr. Peterson.
Thank you very much, Chairman.
Okay, anyone else in the physical or digital world, virtual world, wishing to testify on this little Senate file? Doesn't look like it. All right, I'll close public testimony on Senate File 49. Committee, what is your pleasure?
Move the bill.
Moved by Representative Zwanitzer, seconded by Representative Yang. Any amendments to this bill? Could we could make it effective immediately too.
Just general discussion.
General discussion.
Thank you, Mr. Chairman. In favor of the bill, and primarily because of all the discussion this committee especially has had the last 3 weeks on what we continue to say is your first offenders who were young, who we talked about expungement and trying to ensure people who do one or two stupid things, don't pay for it the rest of their lives. This allows for a process that instead of going through that entire process and then going through another potentially expensive legal process to get expunged, when there is some flexibility with agreement on both sides and a judge. I do like the bill because I do believe it puts the power back in the judge's hands, at least more so than the current law allows in some of these very specialized instances. So I think with all the work we've done on expungement and all those conversations, they all play into if we can, for good cause, prevent that whole process from occurring and then unraveling it all within, is it now 3 years? I can't remember what we set the date finally for an expungement, 3 years after probation and parole. If there are ways to not have someone go through that and everybody on both sides can agree, I think it's a good bill. It has been before the body a couple times and I've spoken in favor in the past.
Oh, Representative Oakley.
Thank you, Mr. Chair. Against the bill. And I think it's interesting, especially when there's not many parts of probably the law that we know really well. And it's interesting to me to listen to some of the discussion and argument because so many, I hear a lot of things that aren't relevant. I hear red herrings. I hear, from just being really involved in the system. I'll say a couple, Mr. Peterson talked about confessions. I think that's a red herring. I think efficiency, I think it's incorrect. I think it would create more trials. I do not think it adds efficiency. And I've given the example. So we have a case, for example, right now where a young woman committed a felony, broke into a house, swung a gun around. But we said, all right, we'll go ahead and give you a 301. So she knows before she pleads guilty, as she walks in, that as she pleads guilty, and if you have a plea agreement, if the judge refused, you could back out of that. Without that agreement in her hand, she pleads, judge says no, she's a convicted felon. Not her defense attorney, not the prosecutor can save her. So at that point, you have to wonder, why wouldn't she just take it to trial then? So I don't believe this creates efficiencies. I think, and so this is what I think it comes down to. When you really understand and figure out who's in the best position to analyze a case, and what would be the appropriate disposition. So all this discussion also about a 301 being a good tool because of leniency, because of what it does, that exists. We're not talking about a 301 not existing anymore, but who's in the best position to analyze that? Prosecutors talk to law enforcement, they study the case, they have to know the case, they might have to take it to trial. They talk to the victims, they get information on that, they get the criminal history. Judges don't have any of that prior to. So a prosecutor gets the criminal history, gets the case, does that, listens to the defense attorney, sometimes endlessly. But we do that, we get harangued. And I know both of the defense attorneys that were here and have worked with them. And I know in the last hearing, Mr. Peterson talked extensively and brought a defendant, that was upset that he didn't get a 301 and the prosecutor did not give that to him. He didn't come here today, but his charge was a 20-year delivery of methamphetamine. We have never given a deferral on that, nor would we. I don't believe a judge would either. But the defense attorney got the opportunity to plead his case for months with the prosecutor. What we're talking about here, that wouldn't happen. So I think the unintended consequences is just as Mr. Barron said, you'll see more, you'll see less 301s, you'll see it used less, and possibly more trials. And at the end of the day, though, I still say it's prosecutors who are via a county attorney or district attorney who are elected, which does matter because what that means is that if they're not giving a deferral on certain types of cases, it's probably because that's what the electorate wants. That's what the people want. So I think this is the appropriate balance as it is. The 301 is a good tool and the prosecutor should continue to analyze that and offer when it's appropriate. So against the bill.
Yeah. It's a little atypical for me to allow
I'm sorry. I guess I missed
legislator
my
to come.
chance to wrap up. I apologize, sir. I'm I don't really believe in prosecutorial perfection. I don't believe the courts are perfect either, but I believe that we set the policy as the legislature. It's not a local control issue about how 301 should move forward. But I want to bring around to, I spent a lot of time, the expungement statute about firearms. That's my bill. I worked with previous governors and attorney generals all in the firearms area because I was horrified that you could lose your firearms rights forever because of a misdemeanor crime that may have not even fit anything like people are thinking that you should, a firearm wouldn't be involved. It's just incredible misuse to not be able to retain your firearms right for misdemeanor convictions. This deferral also provides a tool in that situation. And I appreciate the chance, and maybe I should.
Thank you. No, and not thank you to shutting up, but thank you, Senator, for the additional comments. I will, Representative Williams.
Thank you, Mr. Chairman. I'll be a no vote on this bill. I think that the legislature's enacted plenty of second chance laws, and that's where my vote will stand.
Committee, I'll be brief because the thing about this bill is I think it really comes down to a couple of things, and Senator Case really, when you talk about gun rights, you talk about voting rights. I really think that's a key component here. But we listened to the testimony, and all the testimony we heard today, just committee, really step back and think about this. You heard from prosecutors and you heard from criminal defense lawyers. I know I'm a lawyer, so you probably can't trust what I'm about to say, but I'm not a criminal defense lawyer. I am not a prosecutor. I have never had a criminal defense case in my life, never prosecuted one. It's not my area of expertise. It's absolutely not. But I think this bill comes down to just three simple things. And number one is it empowers judges. It gives judges another tool in their tool belt. I think the second chance already exists in statute. That's already here. We're not adding another second chance. What we're doing is letting the conversation come before the judge to decide whether to grant that second chance, as opposed to stopping it before that conversation ever occurs, which goes to the number 2 point. It doesn't cut the prosecutors out of the process at all. The prosecution has to, and with all due respect to Representative Oakley's point, I do think the prosecutors, and I've talked to Representative Crago about this too. Prosecutors absolutely are right in the trench on the case. They have all the information, they have the facts, they have a lot of that information that the judge isn't going to have until it's presented to the judge. But in the instance a deferral is sought, the prosecutor has the ability to present whatever argument they choose on that deferral. They are not pushed out of that decision-making process. And just think about that. If whatever the prosecutor has in their hands is so significant that they should not grant a deferral, and they make that argument to a judge, do you not trust your judges to make the right decision then? And then, number 3 is the rights component. We've talked about the extreme cases because they're sexy, because they draw our attention. Huge methamphetamine cases, huge drug cases. But we're not talking about the really, really heinous crimes. When we're talking about second chances, what we're really talking about, and I think Representative Oakley even said this, no judge or prosecutor is going to give a deferral to someone with a truckload of methamphetamine. That's not what we're talking about. Did you know it's a felony to steal an iPhone? That's what we're talking about. And should that tool be taken out of the tool belt so a judge can't consider that? Not because of a rogue prosecutor, but because a prosecutor just for whatever reason decided, I'm not going to put this tool in the tool belt. Maybe they have a dispute with the judge that day over a different case. I don't know. So those are the reasons I'm going to vote for this bill. I don't think there's a boogeyman here. I watched this bill go through the other side of the chamber, and I don't normally look at the other side of the chamber, but I looked at the votes on the side of the chamber, and this wasn't a close vote. It just wasn't a controversial issue, and I don't think it's that controversial. but I think it's an important tool in the judge's tool belt. So I'll be voting aye. Representative Washington.
Thank you, Mr. Chairman. You know, throughout my policing career, we didn't call these deferrals, we called them deferred prosecutions. And the way I always pictured it was we had a three-pronged approach. The prosecutor could choose not to prosecute, or to defer. And we trust the prosecutor to make those first two decisions all the time, right? I don't have enough evidence, I'm not going to pursue this case, or I am going to pursue this case. Now, this statute was created, in my understanding, to give that prosecutor a third choice, to defer prosecution for a period of time and see if some of these defendants might, you know, benefit from that third option. I never heard it mentioned in the context of judicial deferral. It was always prosecutorial deferrals. It was a prosecutor's choice to defer or not to defer. And so while I think we've heard some pretty compelling testimony, and the gun rights issue is one that I'm especially sensitive to, I'm going to be a no vote today because I think this is the prosecutor's discretion. And if we're going to trust our prosecutors to make decisions on those first two, prosecute, don't prosecute, we ought to be able to trust our prosecutors to make the decision on the deferrals.
Representative Provenza.
Thank you, Mr. Chairman. You know, I don't think that there was ever an intention in developing our laws to give more power to prosecutors than a judge. The judge has to have experience as an attorney to be able to do that work. It's a higher standard. And so I think giving the last word to the prosecutor is problematic. You know, prosecutors have some of the most power over someone's individual lives and rights than maybe many other elected officials. And I think we hear that the prosecutor's office is overburdened, but we can't take this off their plate. We hear that we trust judges, but we want to give the last word to somebody else. So I think we need to seriously consider that. We need to ask ourselves if we're comfortable with giving the last word to someone that we maybe didn't really intend to in our state statutes. And I would ask that the committee vote for this, and maybe we find ways to work it in the committee of the whole. Thank you.
All right, sensing the question and the desire to vote. All right. Kay, will you please call the vote on Senate File 49, deferral of criminal sentence amendments?
Representative Crago? Representative Larson?
No.
Representative Oakley?
No.
Representative Provenza?
Aye.
Representative Williams?
No.
Vice Chairman Washut?
No.
Representative Yen? Representative Swanitzer? Chairman Olson?
Aye.
Mr. Chairman, you have 4 ayes and 5 noes.